I think that if you... I'm sorry. Yeah, sorry. So the question is, if you do give written quotes for everything, are you opening yourself up to problems where treatment becomes more complicated than it might be, and therefore you've locked yourself into an estimate that you can't meet? Is that the gist of it? I think that's the answer to that question would depend on your experience and your circumstances, but my view would be, if in doubt, give a range. If a scale and clean, as you get older and more experienced, you will be able to pick pretty much everything on the spot. When you're younger and less experienced, or just inexperienced, not necessarily younger, then you should probably give a range of costs. So I would often say to patients, look, this is a 3-canal root canal treatment, and look, I'm just pulling figures out of the air, but you know, it might cost $900 to do this. If everything goes exactly well, I can do it in one visit. However, if it takes 3 visits because of infection and there's some breakdown with the restorative material, then it could cost you $1,500. Now, I'm not going to give 3 estimates, and this gets into practice management more, but I'm not going to give them 3 estimates for each of those eventualities. I'm going to give them a written estimate for what I think it will be. It might be a mid-range figure. I'll express the edges of the range, and I'll put that into the patient record that I told them those ranges, but this is what I think it will be. Does that answer your question? So a range, and I do this in legal fees all the time. I've got a mediation between some unhappy ex-married people next week to do. And I've given a range of fees because I don't know what it's going to be. It could be all day, it could be in the morning, so I'm going to give a range and hope that it comes in somewhere in the middle. But I just think ranges are things that people understand, because you cannot predict absolutely, dealing with humans, what it's going to cost, and dentistry is no different. Don't give 16 estimates of, you know, this canal 16 millimetres, this one's 17, this one's 18, I've got to have to use another file. Just give them a median range, but a top and a bottom range, which goes into the patient record. Does that help? Yep. And then once you've done that, you ask them if they have any questions. So you stop boring. I can swear a little bit, I can't really. Don't bore the shit, no, not like, I know you're worried over there because you've heard it speak before. Don't bore the living shit out of them about the detail of the dentistry, because they're not actually interested. Don't keep talking about how sharp your files are and, you know, how well maintained rubber dam clamps are. They're really not interested. All they want to know is a few things. It's not going to hurt, it's going to last a long time, and it's going to look good, and how much it's going to cost. That's all they want to know. So when you've got your dentist bit over with, where you explain the detail, shut up and say, do you have any questions? And if you're really not very good at this stuff, and I would say most dentists aren't, I actually encourage people in the practice that I still co-own, I would turn to the dental assistant and say, have I covered everything? Because dental assistants make up for a whole range of deficiencies of dentists, including understanding and reading people. And it's useful to say to the DA, if you're not sure, have I covered everything? The DA can say, I don't think Karen understands that aspect of X, Y, or Z. So that's just a good technique to use. But you have to stop and ask them if they have any questions. And then, this is the really important thing, is actually listen to what those questions are and then answer them, which is another step. Yep. Quite like I'm too far away, sorry. So then you should consider the risk factors already discussed earlier in terms of patient risk, procedural risk, and then you move on to consider into Rogers and Whittaker. I'm not going to have time to go through that, although it is an interesting case. You can look it up. Have you heard of AUSTLI? Anyone heard of AUSTLI? AUSTLII? It's a free database of basically all reported Australian cases going back to, I can't remember when. If you look up Rogers and Whittaker, it's very useful if you're trying to understand the concept of consent. So there's 2 aspects to consent. You have to have a subjective and an objective assessment. So a subjective assessment is the particular circumstances of the patient. So if you think, I'm pretty confident this patient's got this, I think she's asked me all the questions she wants, then you have to turn to the objective test, which is to think, if I was that patient in those particular circumstances, would I be happy with what I understand? Do I need to explain to her other aspects which she hasn't adverted to? And that was the key in Rogers and Whittaker, that you just can't say, yeah, she seems to be happy. You have to actually advert to what you would like to know in those circumstances. Does that make sense? I'm making this sound quite complicated, but this whole process can literally take 10 seconds, or it can take half an hour, depending on the person and depending on the dentist and depending on your skills and ability to read people. Okay, so we're getting close to the end of consent. So then you explain the applied risks as you understand them. You explain the costs of inaction. And this is really important, because if you don't tell people what happens if they don't get it done, they won't get it done, and then that's still a bad thing. So periodontal disease is something that needs to be explained to people, because it's not immediately visible, it's ongoing, it's very destructive, and people need to understand what will happen if they don't have a procedure done. And you have to consider finally the emergency or therapeutic privilege. I can't think of too many therapeutic and emergency privileges in dentistry, save to say that the more emergent the problem is, if someone's in a lot of pain with an upper 6, for example, it's plainly got a buccal swelling on it and it's dead as a doornail, you're not going to sit down and explain to them a history of root canal treatment and organic infection. You're going to get some local anaesthetic in, deal with the issue, and then you can explain them and bore them to tears. But if someone's in pain, then you have less of an obligation to explain in detail because of the emergent aspect of the problem. Once you've considered all that, you ask them again if they understand it, and then you decide the form of consent. So will it be written or will it be oral? There's a threshold perhaps where it should be written, but it depends on the individual. You make notes to that effect as to what you've said, and that's why I'm a big fan of dental assistants sitting with a computer monitor behind the dentist, which is quite common in dental practices these days, so that if I'm facing the dental chair that way, there's a monitor behind me and a keyboard, and the dental assistant is typing in what I'm saying while I'm talking to the patient. And that's the most, and I'll talk about an example of that later, of my one and only HQCC complaint, which came 8 years after I treated the patient. And I think it's instructive to show you that later as to, luckily, how to do it properly. So we're there. I hope I'm not going backwards. And inform me before you conform. So before you do anything to a patient, the essence of consent is you must get their permission before you do it. So inform as to what you're doing, and then you do it. If you do something without informing them, you haven't truly got consent. And you should record the conversation contemporaneously, meaning the best form of patient records is a dental assistant who can touch type and type it in while you talk. And that's not uncommon these days. And then again, you ask the patient if they understand. And you might actually do this as the treatment goes on. You know, here's a concept that people don't often get. Just because you got consent at the beginning doesn't mean you've got it at the end. So you have to ask people, are you happy with how we're going? Are you happy with this treatment plan? Am I meeting your needs? Is it everything that you want it to be? These are just 3 or 4 words, but you just have to make sure that people are understanding. And you ask them any time they like if they've got questions. Most times they'll say no. Is anyone in Mount Isa, Townsville or Mackay got any questions? Some of you are still there, some have left, some are asleep. That's okay, I can see that there. So patient records is the next thing. Paul, how much have you got to go when I finish here? I'll go for probably another 20 minutes. Is that okay? That'll be 40 minutes at maximum. Patient records, and a variety of reasons, Paul deals with this all the time, and I do in a couple of capacities, see patient records all the time, and they are, without exception, appalling across the state, and I actually sometimes look at interstate ones. They're just absolutely terrible, the way that people record records and wonder why they get themselves into trouble. I saw one the other day from another state, I think, and a patient had a full clearance as a result of a malignant condition. So you understand the concept, they've got to have chemotherapy and have their teeth removed. And who can guess how many words was in the patient record in relation to all of that treatment? So the patient had come in, it was clear on referral that they needed all of their teeth removed in both jaws. They removed all the teeth and the patient went away. So how many words do you think you can do that in? Full clearance, no, it wasn't that bad, but it was just about that bad. It was something like dental clearance required, extractions, LA. I mean, that was it. So this is in 2012. And it's appalling. And, you know, that's, if as a lawyer, and look, I have to say to you that I'll never get involved in dental negligence because there's so little of it. It never goes to court, and I didn't go to the bar at 51 to be sitting in rooms looking at papers. You go to be in court. So I'm never going to do any of this stuff. But I have to say that if I was representing that person, you would say, you have got absolutely no chance. There's no chance in the world. No one could defend you on those records. And that's a really extreme example. But the other things we see is, you know, people look like they're texting between their girlfriend on a Saturday night, the way that they write the records up, like, OMG, what an effing huge hole. You know, that's not what you put in patient records. And, you know, because the fact is, and we'll get onto this soon, is that what you put in the patient records is ultimately discoverable by, it doesn't have to go to court anymore. Pre-96, before Brendan Williams, you had to go to court and get discovery before people could see patient records. Not anymore. Everything you put in the patient record, and the patient record is quite broad, is immediately accessible by the patient on reasonable notice. So if a patient has an unhappy experience with you and they want to see what's in the record, then you give it to them. You have to give it to them by law under the Privacy Act 2000 and something, 2000 let's say. So it's no joke. What you write in the record is the best evidence of what's happened, and if you don't do it properly, then you need to take it seriously. And that's why, being a clinician working at the pace you have to work at these days, it's not a good idea to write up your notes at the end of the day. When I first started in practice in 1983, end of 82, it was fine. You'd do these patients and you'd sit up at the end of the day. Does anyone do this now, where you sit at the end of the day and write your cards up? That's not good practice. It's just not good practice. Like this afternoon, John, you can't remember when you wrote them up last, no? So why do you keep records? Why do you write down what you do? Well, because it's a good thing, because you'll forget a lot of it. It's because the patient has a right to know what's happened in the e-health promotion that's going on across the country, which is doomed to fail, so don't worry about it because it'll be over with soon. I'll get bored with that. The concept that people can have access to all of their records at all times and all practitioners is just not going to happen. They've been doing it in the US for 10 years. It's fundamentally failed. It's an IT unworkable solution, but the government will spend a lot of money on it. It won't ever happen. But people need to know what they have had done to them, because people are very mobile. Back in the 70s and 80s, people lived in the one town forever. That doesn't happen anymore. People move. People have to have access to their records. But most importantly for putting a record in is not to stop being sued. It's so that you know what you're doing on the patient, so that your treatment can be effectively carried out and reflected upon. That's what you do it for. It's also good to have patient records because occasionally you'll get a patient who will die and they will need to have, and this is not a joke, and they will need to be identified. So a routine, and I'm sure this is taught at JCU, it certainly was at UQ when I was running the clinics at UQ, every patient has every tooth charted as it stands at the first examination appointment. And I know dentists would get out of that habit. But it's a really good thing to do, because I've had a patient who took his own life in very unpleasant circumstances. Suffice to say that the only thing that was available identifiable were his teeth, and they weren't necessarily in an arch. And to have a dental record that the parents, that the police came to me, and I can still remember it, coming to the practice in Gympie and asking for the records, that gave them some closure very quickly, that the child could be identified. So if you do it for no other reason, once in your practicing life you may be able to help out a grieving person because they were able to be identified, because someone had actually taken a proper clinical record of everything in the mouth at some point. So I am not going to ask you if anyone does that, but it really should just be a part of what you do. So what standards apply? Well, look, you can look it up on the website. I'm not going to put up a HDP reference. The Dental Board of Australia has a reference. The Dental Board of Queensland have one. It's worth reading. I know that Dr. Game and I have been corresponding about it recently. It's all there. It's fairly straightforward what is part of the record. So what are common mistakes that people make with records? One is that people don't understand that the patient doesn't own it but has access to it. So whatever you record in the patient's record is yours because you've created it as a practitioner, but the patient has access to it. So patients can't say, I want my record because it's mine. If someone comes to your practice and says, I want my record and it's mine, what could you say to them? What would you do with an irate patient like that? Would you just hand the card over to them, or give them the hard disk, or what would you do? I mean, you don't have to give them the record. You have to give them a copy or at least a summary of the treatment. It depends on your reading of the legislation. And you don't have to give it straight away. You've got time to assemble it, and you are able to charge a reasonable charge for assembling it and making copies. So with digital radiographs and with electronic patient records, generally used in dentistry, are pretty much standard these days. There's no reason that you can't provide copies very easily to patients. But do so with the knowledge that once they've got it, they can do what they like with it, and might make you think about what you put in it sometimes. So common mistakes people make are not handing records over, not really making it understandable about what is in the record and what was actually done. So you should aim for something that's legible, something that's written with correct grammar, because if you do get to a decision maker or a tribunal finder of fact, they're going to be much more sympathetic to you as a practitioner if they can read what's said. So oftentimes I've been asked to review things for people, and I will look, and if it looks like it's been written carefully by someone who's got a brain and knows how to write English and use grammar and actually assemble stuff that makes sense to me, you're going to lose an investigator is going to lose interest very quickly in what's going on. Whereas if you can't understand it, and as I saw something the other day where it looked to me as if someone had used liquid paper after the event, that's not good. That's a word starting with F. You can go to jail for it. Anyone know what it is? And fraud, that's right. So, you have to be very careful about that stuff. Don't alter patient records. Don't try and be clever. Yes, John. FITH, that's right, there's a million of them. I think you should use recognised ones that would be universally known to all dentists. So I don't know how many there are these days, but I think you have to be very careful that it is understandable. So do you want to give me a for instance? And I might... See, I don't know what that is. I'm sorry. Well, see, I know people say UIG or usual instructions given. I think you've probably got to do better than that these days. So I've certainly done plenty of that over the years, don't get me wrong. I'm just saying these days, with computerisation and templating, people... That's right. If you can evidence that in some way, it's fine. But it's much easier to say usual post-operative instructions given, and there's a PDF that you have on your website that you give to everyone that they download and they use every time they have an extraction. Well, it's very easy to show people what you've done, because actually lots of people do refer people to their website, to their intraweb, where they get all the information, and you don't have to worry, say, reference this or that. But yeah, I think you have to be careful with some of the more arcane acronyms that sort of 50-year-old chunkies like me might be familiar with, because lots of people don't understand it. So who's going to read them? And I think you can assume everyone's going to read them. Study models and digital records is problematic. People aren't really sure about this. As a general rule, study models are considered to be part of the patient record, and how long do you have to keep the patient record for? So what's the longest you could possibly have to keep a patient record for? 25 years? That's kind of close to the truth, and that is that it's 18 plus 7. So if you see a child that's 6 months old or 1 month old, you have to keep them to the age of majority plus 7 years. So that's 25 years. So as I hear the other day, someone said to me at a practice I was in, they said, I just shredded all the records of over 7 years old. I said, please don't do that. It's not a good idea. These days, with computerisation and most records and people expecting records being computerised, how long should you keep them for? Forever. There's no reason to dispose of a record. It's not as if you've got boxes full of things. I mean, OPGs, people take non-digital OPGs. Sure, you can store those or scan them, but I really think you're risking, for all the reasons we've talked about, throwing records away under any circumstances. The law and the reality, I hate to break it to you, are often two different things. The law says 7, some people say 10. If you've got a digital record, I think you're obliged to keep it forever and not to dispose of it.